Hello and welcome to this All About Age webinar brought to you by the combined HR Solutions team at Gowling WLG. I'm Ian Chapman-Curry, a Principal Associate in the Pensions team at Gowling WLG. And roughly 1 in 4 people born today can expect to live until they're 90. As well as living for longer, people are increasingly working longer. Over 50s now make up a third of the UK workforce, and well over 1 million people aged 65 and over are in the workforce. As a result, employers are having to navigate the legal issues around an older workforce and age discrimination. So it's great that today I'm joined by Liz Wood and Ruth Ormston, who are both Principal Associates in the combined HR Solutions team and experts on age discrimination. Hello, Liz and Ruth.
Hello.
Hello. So today's webinar will last for about 45 minutes and there'll be plenty of time for your questions at the end. You can ask questions at any time. Just click on the Q&A tab, type in your question and then click submit. And we'll try and answer as many of those questions as possible in the time that we've got today. And we're also going to be encouraging just a bit of audience participation through a couple of polls, and they'll automatically flash up on your screen and they'll be quite simple for you to take part in. But now, just to get us started, it's over to Liz.
Thanks, Ian. Well, this webinar comes at an interesting time for several reasons. The first reason is that in terms of general societal trends, the employment market has for a long time been operating with astonishingly low levels of unemployment. There was a record high in 2018 of 32.4 million people in employment. That's the lowest rate of unemployment in over 40 years, the lowest since 1975. And with a greater demand for workers, regardless of age, and a trend of reduced workers coming to work in the UK from the European Union, it would appear to be only a matter of time before the experience and skill sets of older workers can be truly harnessed. Indeed, in 2018, there was a record number of people aged 50 and older in employment. And age awareness charities have called for employers to ensure that working practices cater for the needs of older people. But because age discrimination claims can be brought by individuals of any age, there is a need to ensure that practices don't discriminate against workers on age grounds more widely. This webinar also comes at a good time because of the recent age discrimination cases, which continue to establish boundaries around acceptable and unacceptable employment practices in age discrimination terms. So in terms of what we're going to be covering today, I'm going to begin by reminding you of the basic principles underpinning the law on age discrimination, including how employers can defend themselves against claims of age discrimination. I'll mention the ACAS guidance, which has just come out on age discrimination, intended to help employers and line managers manage an age-diverse workforce. Ruth will then talk us through the recent and seminal Court of Appeal decision relating to changes which were made to 2 public sector pension schemes in 2015. And there are some really useful lessons there to be learned around how not to make pension scheme changes. We'll then move on to considering age discrimination issues when certain types of other benefits are provided. I'll also cover a helpful but very specific exemption in the legislation, which means you can stop providing insured benefits to employees of a certain age, but if you stop providing the cover at the wrong age, you can't then rely on the exemption. We'll finish off with a roundup of some tips on lessons learned. How can you apply these case law decisions to get it right the first time round? Well, why is it important to consider age discrimination issues? Age discrimination claims are expensive to litigate as a starting point. Considerable time and cost can be spent in defending claims. Claims can also be brought in a range of situations in relation to recruitment practices, throughout an employee's working life, and through to their departure from the business. They're likely to be wanted from a PR and HR perspective. No employer wants to be a high-profile example of discriminatory practices. And as we'll see in the case that Ruth's going to talk about, age discrimination claims can be very complicated and costly to untangle when changes are needed to deal with past practices. So we're now going to look at our first poll.
Thanks, Liz. So we are going to be asking you to identify which of the following statements is incorrect. And I'm just going to push that poll out to you now. Give me 1 second. So what we're going to be asking is which of the following is incorrect: that direct age discrimination can be objectively justified, that in the UK the default retirement age is 65, that objective justification requires evidence of a legitimate aim and proportionality, or finally that there's a statutory exemption that applies to having an age cut-off in life assurance benefits. Now, there's quite a few votes coming in. I'm just going to give it another few seconds. It's quite exciting. You see the votes coming in live. You feel like you're in the ITV studios. It's all very exciting. We'll just give it another few seconds there. But the results show that 77% of you think that the incorrect statement is that in the UK the default retirement age is 65, but a few of you have plumped for direct age discrimination can be objectively justified, or that objective justification requires evidence of a legitimate aim and proportionality. So what's the correct answer?
Okay, I'll step in here, and 77% of you are correct in that in the UK there is no statutory default retirement age anymore because that was abolished in 2011.
Lovely. Thank you very much.
So I'm going to move on now to talk about some of the general principles of the age discrimination legislation that we have in place. So the Equality Act, as I'm sure many of you know, generally outlaws age discrimination amongst the other protected characteristics such as sex, race, disability discrimination and so on. There are four main types of age discrimination, direct and indirect age discrimination being just two of them. Claims can also be brought of harassment and victimisation relating to age discrimination, but I'm not going to look at these last two types of discrimination today, not least because in our experience claims of direct and indirect age discrimination are much more common. Now, direct discrimination can be the clearest type of discrimination to spot. It takes place where an individual, so an employee or a member, is treated less favourably because of their age or perceived age. A good example is where an older person might not be shortlisted for a promotion because they're assumed to be of an age where they might not want that level of stress or responsibility, or might not be adaptable enough, or because an assumption is made that they might not want to work for many more years. Similarly, someone might also not be shortlisted for the job because they're considered to be too young and inexperienced. So in all these cases, assumptions or stereotypes are being made on their behalf which are based on their age and amount to less favourable treatment. The discrimination here means each of those two employees simply won't be given the opportunity to go for the promotion. Indirect discrimination can often be harder to identify. This is where an employer's practice, criterion or provision, a PCP, applies in the same way across a group of employees, but where the impact would put people of a certain age at a disadvantage when compared with the impact on others of a different age or age group. So a policy or practice applies across the piece to everyone, but puts a particular age group at a disadvantage. And a PCP can be anything from a policy, a practice, a treatment, a procedure, a requirement, a rule, an arrangement. We've recently found out in the Court of Appeal's decision in United First Partners research and careerists that even an expectation can amount to a PCP. An example of indirect age discrimination would be requiring that a job applicant has held a driving licence for a minimum period, so for example for 5 years. And this apparently neutral practice, when applied across the board, would impact on younger job applicants, so for example 20-year-olds, because they would be unable to meet that requirement. There are some specific situations where age discrimination is lawful. The Equality Act 2010 sets out a number of specific exemptions that allow employers to provide different treatment in employment on age grounds. So for example, there are limited circumstances where a genuine occupational requirement exists, meaning that someone of a certain age can be chosen for a job. So for example, hiring a girl to act the part in Annie. In broad terms, it's possible for employers to offer different pay and benefits based on an employee's length of service. So for example, additional holiday for longer serving employees. And if differences in pay and benefits exist for employees with up to 5 years service, this is covered by a specific exemption under the Equality Act, and so it's not unlawful. Where more generous pay and benefits are offered by reference to periods of service of 5 years or more, the employer must be in a position to show that it fulfills a business need, so for example, rewarding loyalty. There are also a number of specific pensions exceptions to the general principle that differences in treatment based on age are unlawful. And this is because many pension benefits are formulated, calculated and paid when an employee reaches a certain age. So it seems to be right that there are certain ways in which pension schemes can continue to operate without constantly running the risk of age discrimination claims. However, there are many practices which are not covered by the specific exemptions in the Equality Act and underlying regulations. And in these cases, employers will need to be able to objectively justify the treatment. So age discrimination is not unlawful where it can be objectively justified by an employer. So the PCP, the provision, criterion or practice, won't be unlawful where it's shown as a proportionate means of achieving a legitimate aim. So the employer needs to show that the PCP in question is proportionate, so it's appropriate as a means of achieving the aim of the employer, but it's also necessary. Now, usually the subjective justification is about showing a business need for the treatment and showing that that business need, that legitimate aim, doesn't have a disproportionate impact on the employee claiming age discrimination. So persuading a court or tribunal that judged objectively the act is justified, the ends justify the means. So essentially I always think of this as a balancing act. The employer's aims on one hand, but the impact on the employee on the other. Now, uniquely with age, it is also possible for direct discrimination to be objectively justified. In principle, this means that the same thought process would need to be followed by an employer when defending itself against a claim of direct age discrimination. However, case law has established that the objective justification, which needs to be shown when direct age discrimination is alleged, must be linked to legitimate aims which are social policy objectives. So essentially this creates a slightly higher bar if you're looking to defend yourself against claims of direct age discrimination. And this was explained in the leading Supreme Court decision of Selden in 2012. And in that decision, the Supreme Court said that when you're defending a claim of direct age discrimination, an employer must put forward legitimate aims which are social policy objectives in nature. And examples of social policy aims include aims relating to employment policy, the labour market, and vocational training. And they can't be purely individual reasons specific to the employer. So for example, cost reduction or improving competitiveness, because they're not going to satisfy that public interest test. Examples we've seen in case law as successful legitimate aims have tended to focus on intergenerational fairness, as seen in this slide. So looking at access to employment for younger people, helping the movement of different generations through the workforce, efficient planning for the departure and recruitment of staff, and intergenerational fairness and employment opportunities. And what we've also seen in the case law is that aims based on dignity are less likely to get traction as a defence. Even if an employer establishes legitimate aims, they still must be proportionate. They must go no further than necessary. So again, this comes back to weighing the discriminatory impact on the employees as against the stated legitimate aims. I just wanted to mention at this point as well that we've had ACAS guidance which came out in February 2019 on age discrimination. And this sets out some really helpful reminders of key points around age discrimination. It explains the various types of age discrimination I've mentioned, so direct, indirect, harassment and victimisation. It runs through the various scenarios where age discrimination may happen. So recruitment, training, promotion, pay, terms and conditions of employment, performance management, redundancy, retirement, dismissal and flexible working. But in terms of what we're specifically looking at today, the ACAS guidance is a useful reminder that employers must not have different terms and conditions of employment because of an employee's age or perceived age, but recognising that there are circumstances where different pay, redundancy pay and benefits are allowed, for example the national minimum wage or redundancy payments that follow the statutory redundancy payment scheme. As we saw in the earlier poll, a standard or default retirement age has now been removed, so an employer cannot fairly dismiss someone simply on the grounds of reaching a certain age. Employers can retain a normal retirement age, but to do so must in itself be objectively justifiable and in our experience very rare and very employer specific. As such, employers should assume that employees will remain in the workforce for longer, so benefits shouldn't be removed for employees who remain with the business when they reach a certain age, unless there are strong objective justification grounds to do so.
Okay, thanks Liz. We're going to go to our second poll. This time I would like you to imagine that you're an HR manager who's been asked to close your employer's final salary pension scheme to future accrual. and that's for valid business reasons. Scheme members closest to retirement have said that this is unfair and they've demanded compensation. So do you offer older scheme members protection from the change? Do you compensate all final salary scheme members equally by offering increased defined contributions from the employer for the future? Do you implement and provide no compensation to any members, or none of the above? And I'm just going to push that out to you now. Let's see what everyone makes of it. And Liz and Ruth, you've both had plenty of experience of managing these sorts of exercises. They're certainly ones that you need to think carefully about before you enter into.
Yes, it definitely takes planning, resource, and there are consultation obligations that you need to comply with if you're doing this sort of change. So
yeah, there's lots of different elements, and I think it's one of the areas that we find being that special team that does employment law and pensions law, that we get to see both elements of those. Certainly makes for interesting projects. So just give you another couple of seconds to vote. We've had a lot of responses. We've had people going for all of the options that are available, and I'm going to be a bit of a tease. I'm not going to give you the results because Ruth is going to go through how there's been some judicial commentary on a very similar scenario.
thanks, Ian. So yes, you can think of the answer that you gave as I'm running through this next case. And although I'm using judges and firefighters in the same breath for the next few slides, that isn't because they all participate in the same pension scheme, but the cases that I'm looking at, because they involved similar issues, were eventually heard together and looked at together by the Court of Appeal. So the Court of Appeal decision in Judges and Firefighters actually came out just before Christmas, so some of you may have missed it because you may have already tucked into your chocolate oranges by that point and not been interested. But for those of us who do age discrimination, we were pouring all over this judgment. I'm not going to sound Christmas Day because that would be untrue. But yes, it came out just before Christmas. But firstly, I'm going to give you a little bit of background as to why this case is important and why it came about. So the government decided across the board really to reduce pension costs across the public sector. And that was in response to a review of public sector pension provision in 2011 by Lord Hutton, which made recommendations for pension arrangements that were more sustainable and affordable in the long term. And in response to that report, a number of changes were made across public sector schemes. And in the case of judges, from the 31st of March 2015, the judicial pension scheme was closed and replaced with a new judicial pension scheme. At the same time, the firefighters pension scheme was closed and replaced with a new firefighters pension scheme. And in both cases, the new arrangements that were replacing the old ones were less generous. So I'm not going to go into too much detail, but for example, they included lower accrual rates, so people built up less pension in them. They had a higher normal pension age, and pension was calculated on a career average basis rather than final salary, which is generally less generous for people. And in both instances, as I've put on the bottom bullet of this slide, transitional protections were put in place to protect some scheme members from the impact of these changes. So I'll look at the nature of those protections in a bit more detail in a moment, but the headline is that in both cases, younger pension scheme members, so those who were further off from retirement, were not offered any protection against the impact of the reforms. And this resulted in a lot of them being very unhappy, and more than 200 judges and 6,000 firefighters brought claims before the Employment Tribunal, saying that they were treated less favourably than those who were offered protection on the grounds of age, and that less favourable treatment could not be objectively justified. Interestingly, in these cases, female claimants also made a claim for equal pay under the sex equality rule on the basis that the transitional provisions disproportionately adversely affected women. and certain claimants brought claims of indirect sex and race discrimination on the basis that these transitional protections put women and black and minority ethnic claimants at a particular disadvantage. And that's essentially because they had sort of entered the profession later, so were generally younger. And that's quite an interesting point, I think, because it doesn't really occur very much in the pensions world in particular, but there wasn't a final conclusion on this issue, and there didn't really need to be, because as we'll come on to see, they were successful in their age discrimination claims. So what were the transitional protections? The challenge really was on these rather than on the change as a whole. Broadly, the transitional provisions put in place for both schemes gave some active members of the existing, more generous scheme full or partial protection under that scheme by reference to the member's age. So older members who were closer to retirement had full protection in terms of their pension rights. So what that meant was they were allowed to remain in their current, more generous pension arrangement and continue to build up benefits on that basis up to retirement. Members who were slightly younger had some protection, which reduced year on year, and that was known as the tapered protection group. And members who were younger still and reached normal retirement age after a certain cut-off were offered no protection at all. And the claims here came from the unprotected and the tapered groups, who argued that the decision to exclude them from the either tapered or full protection group was age discrimination. And there was a huge financial impact of this different treatment for younger pension scheme members. So it was estimated that for a firefighter who was too young to benefit from the transitional protection, they would need to invest approximately £16,000 to £19,000 a year to provide the same benefits as older members who'd been given the same protection. And for judges, because of the combination of the fact that the younger members had no protection, but also the fact that the new pension arrangement offered to them was on a different and less generous tax basis, the cost was estimated to be around £30,000 a year for them to be able to provide similar benefits. So clearly quite a huge financial impact. And as in many cases involving age discrimination, as Liz has covered, the key question here was whether those transitional protections were objectively justified, i.e., were they a proportionate means of achieving a legitimate aim. And the government, so here the Ministry of Justice and Secretary of State, argued that the transitional protections were designed to protect those who were closest to retirement from the financial effects of the reform. So there was speculation that older judges would be more likely to have fixed or concrete plans for retirement, which would be difficult to change. There was an element of treating all public sector pension people consistently, because there'd been this 10-year protected period sort of incorporated into other agreements with trade unions and other workforces. And there was also talk about a moral and political aim of being fair to those closest to retirement. So in the firefighters' case, they argued that the moral and political argument simply felt fair. And when these cases first went to employment tribunal, there were actually contradictory outcomes. So the employment tribunal in the judge's case found in favour of the judges and said, yes, this is age discrimination. Whereas in the firefighters' case, they came to an opposite conclusion. So it was a different tribunal judge, I should say, making these two decisions. And they concluded that actually there was a legitimate aim, it was subjectively justified, so it was fine in the case of the firefighters. Both decisions were appealed to the Employment Appeal Tribunal, who found in favour of the judges and the firefighters, but for different reasons actually than the Court of Appeal. So because we're focusing on the present law here, if you want to go back and look at the original decisions, you're very welcome, but probably more interest to you is the actual Court of Appeal decision, which is the current position. So the Court of Appeal held that the transitional protections were unlawful, so they couldn't be objectively justified. And in both cases, the failure was on legitimate aim, so establishing that first part of the objective justification test. There are some interesting comments in the Court of Appeal judgment on the margin of discretion. So that's the correct approach that should be taken when looking at objective justification where the state has a legitimate interest in the issue, so where you've got that kind of public policy interest. He said that a margin of discretion isn't completely open and doesn't just leave them to name whatever legitimate aim they want and for them to have no evidence behind it. And that both younger judges and firefighters had been discriminated against in this instance. And key was the fact that there hadn't been sufficient evidence to support the rationale for these provisions. So in the case of judges, the court said there's just no evidence that older judges need more protection in terms of their pension than younger judges. If you actually think about it, it can very much be argued the other way, in that the older judges have had the more generous benefit of accrual for longer, so may need less protection than the younger judges. And in the case of firefighters, although there have been claims that it felt right to protect older firefighters and the decision to do so was a moral decision, the court said no, that's not good enough, you just don't have the evidence here. So having failed at that first hurdle of the objective justification test, the court actually only looked at the issue of proportionality pretty briefly. In relation to judges, it commented that the fact that the younger judges were worse off because they had no protection, but also worse off because of the tax status of the new scheme, was in itself a disproportionate means of achieving any legitimate intended aim. So key message here is really, don't assume your legitimate aim will be taken as read by a tribunal. Can you show evidence behind why that legitimate aim is important and why it actually applies to your business? So what next? Well, the government's seeking leave to appeal the Court of Appeal's decision to the Supreme Court. If they are unsuccessful, if they're granted appeal, then there will be some serious cost implications here. So one estimate I've seen says that this could cost the government in the region of £4 billion per year to sort out. So it's a very expensive bill, potentially for, I guess, the taxpayer in the end. They'll need to compensate those who are in the non-protected or tapered groups for the less favourable treatment that they have received, as well as working out what they're going to do going forwards. So how do they sort this out going forwards? Do they level up or level down the benefits? They'll need to do more consultation, presumably, with their workforces. So it's all potentially very messy. What about if you're a private sector employer? Because you might be sat on this webinar thinking, okay, well, the public sector seems to be a bit of a mess, but it doesn't really affect me. I'm afraid that's probably incorrect. You may have a broadly comparable scheme in place that is based on a public sector scheme where you may have put in transitional provisions to mirror those that exist in the public sector scheme. So if those public sector scheme transitional provisions fall down, then you'll need to revisit your own broadly comparable scheme. Equally, you may have just done a past closure exercise on a completely private scheme and had transitional provisions going into that exercise, and some of the arguments that have been applied in the Judges and Firefighters decision will also impact you. They may be opened up to scrutiny. And what about future benefit liability management exercises? Well, I think there has been a bit of a sort of trend in the past of potentially compensating older workers, looking at cushioning the blow for those who are closest to retirement, making sure they're not too badly affected because they've really started to focus and look at their retirement potentially. If you introduce transitional provisions for one particular category based on their age, are you just opening yourself up to unnecessary risk on an age discrimination basis? So I'm now going to hand over to Liz, who's going to cover a recent decision to do with share schemes.
Thanks, Ruth. So the Court of Appeal has given guidance on a situation where invested share options are lost or retained depending on the employee's age. And this may sound like quite a specific point, but the decision is also a very helpful reminder of how best to defend yourself against allegations of direct age discrimination. So here Mr. Cockram, a long-standing employee of Air Products plc, retired from the company, and he was aged 50 at the time of his departure. Whilst in employment with Air Products, he'd been a member of the company's long-term incentive plan, the LTIP, and under this he was offered stock options. At the time of his departure from the company, he had unvested options, but these options were forfeited because he left the company at age 50. Now, had he retired aged 55 or over, he would not have lost those unvested options. And this is because there was a retirement exception in the LTIP's rules, which said that invested stock options would not be forfeited, had the employee left employment on or after the customary retirement age. And for the company, the customary retirement age was age 55. Mr. Cockram brought a claim of direct age discrimination. In particular, he was not happy because he personally had a protected pension age of 50 in his defined benefit pension scheme with the company. And so he felt that he should have still had those share scheme options available to him when he left at age 50 from the company. So was this direct age discrimination? Well, Air Products accepted that the rule in the LTIP was direct discrimination. It was direct discrimination because an employee in the same position as Mr. Cockram, but aged 55 at the time of his departure rather than 50, would not have forfeited the unvested stock options under the retirement exception. But Air Products sought to objectively justify the rule such that it was not unlawful, and it was relying on two main reasons. The first was intergenerational fairness and consistency. Air Products wanted consistent treatment between employees in its defined benefit scheme and its separate defined contribution scheme. Air Products said that members of the defined benefit scheme were already in a more favourable position than the DC members because, firstly, the defined benefit pension was more generous, and also a number of the defined benefit members could already take their pension at age 50 rather than 55, which was the case for the defined contribution members. So if employees who were in the defined benefit scheme were also able to retain their unvested LTIP awards when they left the company at age 50, rather than 55 as for the rest of the workforce, this would be increasing their advantage over defined contribution members and the intergenerational unfairness already existing. So to keep the retirement exception applicable to all employees, assuming a customary retirement age of 55 promoted this intergenerational fairness of the company. And the second reason Air Products put forward was rewarding loyalty and experience. It said the purpose of the LTIP and this particular provision was to strike a balance between encouraging retention of employees up to a point, but then providing an incentive to retire in order to create opportunities for younger employees. So that's that social policy element that I was talking about earlier. And Air Products said the cut-off point was legitimately age 55, and that was the customary retirement age. Now, the Employment Tribunal rejected Mr. Cockram's claim. It accepted that the discriminatory effect was objectively justified, taking into account those stated aims of the employer. Mr. Cockram then appealed to the Employment Appeal Tribunal, and it said the tribunal's decision was wrong and sent it back to be reheard by a differently constituted tribunal. It then went up to the Court of Appeal. The Court of Appeal agreed with the original tribunal decision and dismissed Mr. Cockram's complaint. Importantly, the court looked at that guidance that I've mentioned in the earlier decision of Selden in considering whether social policy objectives existed when the employer was looking to objectively justify its direct discrimination. And the Court of Appeal accepted that those good legal provisions could be objectively justified. It accepted that the employer's legitimate aims of achieving intergenerational fairness and consistency were legitimate aims. Intergenerational fairness is a broad objective. It can be framed in lots of different ways depending on the circumstances. And the Court of Appeal accepted that limiting the advantage enjoyed by one age group over another is a legitimate social policy aspect of intergenerational fairness. The consistency point was important because the Court of Appeal also agreed that although Mr. Cockram personally had a protected pension age of 50, which meant he could take his pension scheme benefits at that time, most members of the scheme, the defined contribution scheme, could only take their pension from age 55, and it was okay for the employer to take a consistent approach to the LTIP's customary retirement age. And the Court of Appeal also accepted that the submission around rewarding experience and loyalty was also appropriate, and it wasn't disproportionate in its application here. So the Employment Appeal Tribunal had been wrong to overturn the tribunal's original decision. So although the decision in Cockram was looking at the very specific terms of one employer's share scheme, I think the court's guidance is really helpful to reassure employers that well thought out rationale for practices can be a solid defence to an allegation of age discrimination. In particular, as we've seen, Cockram provides a helpful reminder of the potentially legitimate aims when an employer is faced with a claim of age discrimination. And many of those aims, such as creating a balanced workforce, promoting recruitment of younger workers, can be summarised as intergenerational fairness. On the other hand, and a point that we haven't mentioned today in the webinar so far, is that cost saving alone is not a legitimate aim. So employers do need to look at other reasons as to why it's put in place that practice. If they do have a legitimate aim, employers need to show that their actions are proportionate. So it comes back to that balancing exercise I mentioned earlier, and evidence will be important to demonstrate this and support the employer's defence. The final point I want to cover today is a reminder of how insured benefits can be provided to employees in a way that doesn't fall foul of the age discrimination legislation. When the default retirement age was removed in October 2011, there was lobbying from employers who feared that they'd be exposed to age discrimination claims because they said it was just simply too expensive to provide continued health, medical and life insurance cover to employees who were older than 65. And there was a wider concern from the government that employers would simply withdraw these types of benefits wholesale across the workforce because of the increased cost in offering them to older employees. As a result, we had changes in 2011 to the legislation, and there's a very specific exemption which allows employers to withdraw insurance or a related financial service to employees aged 65 or over state pension age or greater. So what this means essentially is that an employer can stop offering group risk insured benefits when provided through a third-party insurer to employees once they reach age 65 or state pension age, if greater. But there are some quirks you should be aware of in the exemption. Firstly, unless the employer is itself an insurer, the exemption only applies where the insurance is provided by way of an arrangement with a third party. So the exemption only bites where the employer has taken out those benefits through a third-party insurer. If the employer self-insures, so covers the cost, for example, of death benefits itself, it wouldn't be covered by this specific exemption. As such, if it chose to stop offering a self-insured benefit to an employee, it won't get the benefit of the exemption's protection, and it would need to objectively justify any decision to stop providing the benefit if this was connected to the employee's age. Secondly, a separate quirk of the exemption is that it is only framed by reference to the employer stopping providing the benefit. And it's relatively common in our experience that employers offer these types of benefits through occupational pension schemes, which may have their own insurance policies underwriting these benefits. The exemption doesn't refer to trustees holding insurance, and so it's never been clear whether trustees of a pension scheme would also benefit from the exemption. But in our view, if a trustee board was faced with a claim of age discrimination by a scheme member in relation to a decision to stop providing this type of benefit because of the member's age, we would expect the trustees would be able to piggyback or rely on the employer's objective justification defence in order to defend themselves. Finally, the exemption doesn't protect an employer if it chooses to stop providing the insured benefit at an older age that is not the employee's state pension age, or 65, so for example at age 70. And at that point, again, the employer would need to look at those objective justification grounds to stop providing the benefit at that age. If an employer doesn't have objective justification grounds for withdrawing the benefit at that age, an alternative option may be to choose to self-insure in respect of the employee from age 70, rather than run the risk of age discrimination claims. So this slide just thinks about the questions to ask and consider if there's any consideration of removing insured benefits at an older aged employee. So I'm just now going to hand over to Ruth for some conclusions.
Okay, thanks Liz. So what can you take away from all of this and from some of the case law? Well, hopefully you will consider age discrimination if you're making any changes to benefit structures within your workforce. And don't forget about indirect age discrimination as well as direct. Check the exemptions, so there are some contained in the Equality Act, which Liz covered earlier, and there's also a specific set of exemptions that applies to pension schemes. But don't be fooled into thinking that that can therefore apply to anything you're doing in relation to your pension scheme, because as I demonstrated through the analysis on the Judges and Firefighters, won't necessarily apply to transitional provisions when you are changing your pension scheme. Consider objective justification, and remember there are two limbs to this test, so you need to satisfy both in order to show that a practice is objectively justified. I think the case law for me has really spelt out that you need to test your legitimate aims. So what evidence do you have? Are they specific to you as an employer? If it's direct discrimination, do you have a wider social policy objective? And although you can articulate or come up with your objective justification after the event, it's probably preferable to do it when you're thinking about the actual practice so that you know what evidence you might have in relation to it. So in conclusion, just going to really hammer it home. Think through your legitimate aim. Will it stand up to scrutiny? Don't just pick a legitimate aim that you've seen